A federal judge dismisses the Trump Department of Justice lawsuits against former FBI Director James Comey and New York Attorney General Letitia James. Are those suits likely to be revived? Should they be? And what does the lawfare battlefield actually look like these days?
From the opinion pages of the Wall Street Journal, this is All Things with Kim Strassel.
Welcome to All Things with Kim Strassel, and our guest this week, who has followed all of this closely and is one of my favorite legal analysts, is Jonathan Turley, the Shapiro Professor of Public Interest Law at George Washington University and my fellow Fox News contributor. Professor, thank you for joining us this week.
Thank you, Kim.
Yeah, the legal environment has kept you pretty busy this year.
Yeah, business is good. Business is good. Well, probably means the republic is falling, but business is good.
Well, we're going to get to that. Federal Judge Cameron Curry, a few weeks ago, as you know, dismissed federal prosecutions against both Comey and James. Comey in September was indicted for lying to and obstructing Congress in 2020 with regard to leaks of sensitive information to the media. James was indicted in October on bank fraud and false statement charges related to a mortgage she took out on a home. Both cases were dismissed essentially on procedural grounds, not necessarily because of the merits of the case, but on issues related to the legitimacy, as it were, of the cases being filed by Lindsay Halligan, the acting U.S. attorney for the Eastern District of Virginia. In your mind, was it correct that these cases were dismissed?
I think it probably was correct. It was dismissed without prejudice. When these indictments first came down, a couple of us noted that they had gone forward with someone who could be challenged as lacking the authority to sign off on these indictments. And it comes down to a rather arcane statutory provision that most people are completely unaware of, which is when you have a vacancy for a U.S. attorney, a president under the statute has a specific 120-day period in which you can appoint an acting U.S. attorney. Once that period is gone, once it is expired, the authority to appoint the acting U.S. attorney then shifts to the district court. Now, in this case, the predecessor here had already served that period. And so the administration tried to get around that by saying, well, we're sort of calling her a special prosecutor, and it's not really the same thing. And this is intruding upon the authority of the president. Those arguments are not very compelling. And I think most judges would come to the same conclusion. So I did not feel this was a promising appeal. In fact, I thought this was virtually inevitable that they would have this type of dismissal. Now, it doesn't mean, however, that the day is done, because as you note, Kim, this was the ultimate procedural basis for a dismissal, and there are ways around it.
Well, I want to get to that too, about the individual cases and the merits of those cases. But on this question of Lindsay Halligan, the attorney who was disqualified, as it were, or the reason that these were dismissed in the end, I mean, I'm not quite sure people know either how big of a thing this is now becoming in the Trump administration, because it's not just in the Eastern District of Virginia. Alina Habba just resigned as the U.S. attorney for New Jersey after an appeals court found her ineligible. Courts have essentially disqualified acting Trump-chosen attorneys in California, in Nevada, in New York, in New Mexico. A judge just this week also suggested Halligan needed to resign her position. Trump's handling of this Vacancy Act provision that you are talking about, I mean, it does seem to be highly unusual and very aggressive. Is the law really that unclear, or is this something that at some point the Justice Department is going to have to deal with the fact that they're going to have to turn back to the Senate to get some of these people officially confirmed?
You know, the administration does have good faith arguments, but I would not call them particularly strong. The statute could not be more clear. I mean, it's a very cut and dry statute. It gives you a period to appoint. Within that period, after that, it goes to the chief judge of that district to fill the gap. This administration has had tremendous success in challenging certain rules, particularly when it comes to presidential powers. We just saw this week a very promising oral argument in front of the Supreme Court over the right of the president to fire commissioners on independent commissions. When the dust settles, I think that President Trump may be the most impactful, transformative president on executive power since FDR, maybe even since Washington. I mean, the cases they've won have made substantial changes in the tripartite system. So you have to give them credit for that. Where I've been somewhat critical is that you can't fight on every hill. You can't take every 3-point shot. Someone's got to be a sort of mature, adult in the room and to say, look, why are we fighting this? In my view, they could have had this signed off by an AUSA who was properly commissioned. Now, that worries me that they didn't do that because it may suggest, as was rumored, that this particular office, when it came to Comey, was in almost mutiny over this indictment. Halligan's predecessor was no anti-Trump figure. He
Right.
was a loyal Trump supporter, but he really balked at this and said, I don't think that this is a legitimate indictment. So when they took this on appeal, I was also scratching my head because the judge gave you a gift by doing this without prejudice. So you can go back and you have a certain period of time to get a new indictment. Now, does that mean the merits are particularly strong? No, I think that Comey case is really tough. One of the things I noted about Comey is that the grand jury returned a no true bill on one of the counts. And they were so close to the wire, which is, by the way, really negligent. But they were trying to do this as the door was closing within hours. And they didn't have time to clean it up. So when the indictment came out and I read it within a few minutes, I tweeted out, there's something missing here. I mean, it doesn't read like a coherent, flowing indictment. And what I suspect happened is that when they delivered that no true bill, they took out the core linking count.
Right.
And they just stitched the two parts together. They didn't make a lot of sense. So the Comey indictment really was difficult. The key about this that I've said for years, and I'm a criminal defense attorney by training, is when it comes to criminal law, novelty is not good. Okay, the judges don't like novelty. They don't like the novel. They don't like improvisation. When you're talking about putting someone in jail, judges tend to read these laws very strictly, and they read them in favor of the accused.
Now, explain something to me. There's a couple of ways that they could go about reviving this Comey indictment if they wanted to. I mean, one is to simply try to make the argument. They can appeal it, right? They could appeal it up and say, actually, this indictment should stand despite the vacancy question because we have a powerful case here, et cetera, and so on. I guess they could also try, and this is what I don't understand, could they simply try to revive it under another prosecutor, or is there a statute of limitations problem? And if they did it again, do they go back to the grand jury again and try to make it a stronger indictment, or is that just simply done?
No, the defense can challenge whether they're out of time because they waited until the very last minute. I think they've got a good argument that they have 6 months under another provision. And in my view, an AUSA that's properly commissioned could sign off here. So that's what is really the intriguing question here, is that I don't understand why they wanted this person to sign off in this way. Now, I also have to note that this is not a muddle of the White House's making entirely. I think there were some mistakes made here, but the Senate has prevented this president from appointing U.S. attorneys. And I think it's outrageous. And they're using the blue slipping process and slowing everything down. And there used to be, as you know, Kim, a sort of rule of engagement that you could hold back some on blue slipping, but it was pretty rare to try to shut down the entire process. And that's what they've done here. And, while we can debate whether the filibuster rule should be removed, I think there's strong arguments why the Republicans should keep it. I think there are pretty compelling arguments against blue slipping. I've never liked blue slipping for judges or for any nominees. It's true, it forces you to compromise, but it also just sort of further increases the sort of feudal powers of these senators. And we don't need that.
Well, since you bring it up, I actually did want to ask you a question on the blue slips. Now, both parties have used it, by the way, and I would point out that one reason why it is unlikely to go away is because there are many Republicans that are very firmly committed to it. So you probably couldn't get the numbers that you needed to actually push a rule change through. And I think Chuck Grassley, who heads the Judiciary Committee, he likes to point out that even if he abolished the provision, he's got at least one member on his committee, Tom Tellis, who said that if a blue slip has not been returned for a nominee, he would vote against them in committee anyway.
Right.
So if you have all these Republicans who very believe strong, firmly, and again, like you said, we can debate. But here's my question. Donald Trump was so frustrated by the blue slipping process back in August. He said that they were going to file a lawsuit against blue slipping on constitutional grounds. Is there any because I agree with you. I think this president has done some really important legal work when it comes to clarifying the powers of the executive branch. But do you think that's another one that's kind of aiming in all directions?
I'm afraid so. I mean, you can't all cap it away in a late night posting. I mean, this is the president. When the president, his first term, when the president was coming into office, I wrote for one of my papers a column, I think on Inauguration Day, warning that people should be prepared about. I didn't know Trump very well, and not many of us did, but I said, you better be prepared. This is going to be a president of a different kind, in the sense that we've never had a president who was a pure businessman, but more importantly, someone who cut his teeth in real estate, let alone New York real estate. And the column talked about the fact that New York real estate is the most litigious area of the country. And people in that business, their first response is always to sue, no matter what happens. They sue. And I said, you're going to have a president that's going to take that. That's how he made a lot of money. And it's turned out to be prophetic, I'm afraid. And he's still,
no kidding.
Yeah. And he still has that quick trigger, sue him, go to court. Now, in defense of Trump, and I've said this to crowds that are not favorable towards him, I said, look, at the end of the day, he complies with court orders. You keep on calling him a king, but throughout his first term, he had just haymakers delivered by the courts, and he complied. He challenged them. He appealed them. So in Trump's view, he's using every shot he can take. Now, for some of us, that's not a great thing for a president to do, because it can reduce the credibility of your administration in court. He's got some really good lawyers. I mean, he's got a great White House counsel. I got to tell you, I think he's got one of the best solicitor generals I've seen in action. He
was good this week in particular.
He is really good. And look, I thought Biden had a terrific solicitor general. So I think that, he's a match for her. I mean, he's really good on his feet. So, he has these good lawyers in that administration. But he is really sort of pushing them into litigating and challenging everything. And I think that hurts. So I think this is a mistake to appeal this. In terms of blue slipping, it won't work. The courts have said over and over again that the houses of Congress can establish their own internal rules. I represented the House of Representatives in federal court. And, one of the things that you always had is to be able to say, look, we set our own rules. And we have to stay within our navigational beacons. But when we're inside those beacons, courts usually stay the hell out.
Yeah. And, those rules in this particular case, this blue slipping thing, I would also just throw in to echo what you're saying, go to a core Senate power, to the Senate advice and consent power, which is very clearly belongs to the Senate. I wanted to ask, just since you use the word all caps, and you mentioned that the team has the White House has a very excellent legal team. But I do wonder sometimes, and this gets back to the Comey case, if the president and his all cap tendencies can also kind of make their jobs harder at times. And Comey has argued that this is a vindictive or selective prosecution. And he certainly has some argument to make there, given the president essentially told his people to go after him, and has made a lot of comments about him. I mean, how strong do you think, if this case were revived, are his grounds for making that case?
Well, normally a selective or malicious prosecution case, I would say, has less than a 1% chance of success. I brought those against prosecutors as a criminal defense attorney, and I can tell you at least one of them I thought was an open and shut case of malicious prosecution, and the judge just didn't want any part of it. And the reason is that judges look at these issues as, is there a valid criminal charge here and a valid underlying indictment? And I don't want to get into the motivations behind it, because down that road lies madness. And so I'm just going to look at, was your client properly indicted? And is this a properly laid crime allegation? And the problem here is that the president really made a big mistake there. He issued this thing saying, you need to indict Comey and you need to indict James and these other people. And then he withdrew that posting, but it was way too late. And so in the dismissal of the Comey and James indictments, the judge quoted the president at length from those social postings. Now, I thought that the judge was wrong to do that, because judge justified it by saying, look, they were in a rush. I thought it was a bit gratuitous, because frankly, it's not that relevant to the technical issue.
Right.
But it's going to come up again. And it does put the malicious selective arguments a bit closer than they would, significantly than they would normally be. I mean, he puts out that post, and then soon thereafter they indict them, and the indictment seems sort of thrown together. Look, you can't create a better record than that. Now, does that mean they're going to succeed? No. You always bet against selective and malicious prosecution claims, but it makes this much closer.
Yeah, I agree with you. I was very disturbed when the judge went there, because, as you note, this was being dismissed on a technical ground. And by bringing it up, she almost seemed to be pointing defense attorneys, saying, you want to go down that road? I'll bite. Let me ask, just on this other case, since I opened by talking about the Letitia James prosecution too, do you think, same question there, do you think it will be revived? Should it be revived? Is it a strong or a weak case?
Well, we just saw a report out of Norfolk that they presented the James indictment again to a grand jury, and they rejected it. Now, whether that account is correct or not, we don't know, obviously.
Right.
But, these are difficult claims to make. I mean, James, it's not so small like ripping a label off a mattress, but what James did is pretty ubiquitous. I mean, a lot of people say this on these forums. She can most certainly be re-indicted. In her case, by the way, that indictment held together better. It was coherent in the sense of, they're accusing her of making a false statement on mortgage papers, and that certainly is a crime. And I think that it would probably withstand any challenge on its face. Now, you still have to do the malicious and selective prosecution claims, but you would have to win on those. So that could be brought again. The question is whether these accounts are true and that grand jurors are not really enthused with these cases.
It's impossible to talk about these cases, and obviously the mainstream media does all the time, without putting them in this larger framework of lawfare. Of course, the media likes to forget that there was lawfare that preceded any lawfare we're seeing now. And of course, Tish James was front and center of that with a Trump prosecution alongside a separate Trump prosecution brought by Manhattan DA Alvin Bragg, and the one down in Georgia by Fani Willis, that were, I think, little more. It was certainly my view, little more than the raw weaponization of the law to go after a political opponent. How do you, though, look at these Trump prosecutions in that broader realm? I mean, do they qualify as lawfare, or, as his supporters say, are they simply about accountability? It can become very difficult at times.
It can. The difference between these cases and the cases against Trump is that there is a scintilla of merit here. I mean, with the Trump cases, they were absurd. I mean, the case, the criminal case of Smith, in my view, was just raw lawfare. But the New York case in front of Judge Manchin, I thought, was almost comical in how off base it was on every single level. I covered that for Fox. And at one point, I actually guffawed in the courtroom and got the stare from Manchin. And it's not something I didn't realize I did it. And it's the only time it's ever happened. But he had just, the defense attorneys had made an objection, which was right on all fours, like right down the middle. And in fact, Manchin had agreed to that objection by the prosecutors, and he turned it down, and I let this sort of small, like, sucking sound get out, and it did not please the court. And I was
been there.
I was very embarrassed, because I was like, oh God, I'm not at home on my couch. But
were you reprimanded?
No, but I got sort of this look over at me like, eh. But, if you look at, for example, what happened in Atlanta, that was the dumbest RICO case I've ever seen in my life, and I've seen some doozies. And I think that my colleague McCarthy had the greatest description of it. Andy said, this first racketeering case I've ever seen, where the only contact between any of the parties was to be listed in this racketeering criminal complaint. And he really did capture it. I mean, these people had no connection to each other. So that also collapsed. The difference is that, look, I'm a big critic of Comey's and James. I think Comey is really a sinister figure, quite frankly.
Oh, I agree with you.
And so, I do think that there's questions about whether he lied under oath. I admit that he's very good at testimony, and people can disagree about that. But if you look at Comey and James, the issue is not whether there's nothing there, that these would not be crimes, as much as how serious are they. And these types of objections have been raised, are rather ubiquitous, particularly in testimony to Congress and statements to investigators. Now, there's no question that if you apply the standard from the Trump period on what they used against those figures, people like Flynn, these are certainly as strong as those cases. I mean, but that doesn't necessarily mean that they're cases that would be pursued if the president was not pushing the Department of Justice.
Yeah, well, and one problem for me, which I sometimes point out to people who really want to see some accountability for especially a figure like Comey, is this also doesn't really bear much relation to the actual sinister things he did while he was. It's a small kind of ancillary issue to a certain degree. My own worldview is I save a lot of scorn for our civil institutions that used to met out a different kind of punishment for people who really did abuse their positions of power, which was that they were called out and humiliated, and then they were not given other positions positions instead of our media and TV stations, et cetera, that these days that reward the Comeys of the world with book deals and professorships and, TV contracts, et cetera. And it leaves everybody feeling that the only option is to go after them with law. But that's my own little,
Yeah,
my,
great.
my moralizing. Let me ask you this just as a kind of a closing question, because I'm fascinated and disturbed by this turn that we've had to lawfare ever since the beginning of the Trump years. It's essentially people trying to accomplish legally what they can't accomplish politically. But if you look out there, you just mentioned, Tish James's case essentially has collapsed. The Jack Smith case is ended. Fonnie Willis's case is gone. There's a couple that are on the Manchin case you mentioned with Alvin Bragg. It's sort of on abeyance, as it were. It may or may not ever come back. But how do you assess where we are in this lawfare arc, as it were? Like, have people learned lessons? Is it getting worse? Are people realizing that it's not getting them what they wanted? Like, where do you see we are at the moment?
It's interesting. I just had a debate with a Harvard law professor who is one of those democracy's dying people. And one of the things I pointed out was I have no idea what you're talking about, because everything that you've objected to, courts eventually overturn.
Right.
So the courts are actually functioning. They're ruling against both sides. And Trump has he's a little lower than average in terms of his win rate in front of the Supreme Court. But if anything, he's below it. While everyone's saying you've got these robotic conservatives on the Supreme Court. So the system is functioning as it was designed. That doesn't mean, however, that people have learned their lessons. I think a good example of that is New York. I mean, people in New York like it. When I just wrote not long ago this book on rage and free speech. And rage is an odd thing. It gives you a license to say and do things you would not ordinarily say or do. And it is addictive. What people won't admit is they like it. And it is contagious. When the verdict came down in New York, I was asked to be in the courtroom for Fox, and we all ran out to be on camera. And when running out of the building, there were people dancing in the street. It was ecstasy, and that's really the face of rage. And if you look at the New York system, the New York bar has not covered itself in glory. They have allowed the New York legal system to be used for raw lawfare. And, even though the court recently gutted James's case and just took basically all the air out of it, they still sort of kept the case alive, sort of mostly dead. They lacked the courage to go all the way and say what it was. So I don't think anyone's learned any lessons. But the court system, I think, has proven itself again that it's able to withstand an age of rage.
Well, on that, I'm an optimist. So on that optimistic note, that our court system is showing some resilience against all of our worst instincts. I want to thank you, Professor, for coming on. I'd like to also recommend your book to everyone, Rage. I read it. I really enjoyed it. I want to thank our listeners for tuning in. If you like the show, please do hit that subscribe button, and you can write to us at atkim@wsj.com.